We are here in the matter of Louise Kanaga versus Amway Hotel Corporation.
And this case comes before the court today on various pretrial motions. I would invite counsel to place your appearances on the record, beginning with plaintiff.
Yes, good afternoon, Your Honor. Matthew Swartz on behalf of the plaintiff.
Thank you.
Your Honor, good afternoon. Adam Townsend, Mike Boval, and the newly admitted Natalie Patterson on behalf of the defense.
Very well. Welcome. You're all labeled on my screen as Mike Boval 1 and Mike Boval 2. So, but I'll try to keep track of who's actually addressing the court here. Welcome back. And I will take these pretrial motions one at a time. And this is in no particular order right now. I've got plaintiff's motion to compel prior incident reports, internal messaging, and imposition of discovery sanctions. I did review the motion. It looks like these are some sort of internal system maintained apparently by the maintenance folks at the Amway that you have attempted to get printouts of or documents of for a while and do not have any. Is that accurate, Mr. Swartz?
That is correct, Your Honor. But briefly, we did motion this for Monday, just so Your Honor is aware. I don't know what is going. Yeah, so I mean, if defense counsel wants to address it today, we can. I would think either they have the documents or they don't. But if they want to or need to defer till Monday, I can't. You know, the hearing was noticed for Monday. So
Got
for what
it.
it's
All
worth.
right. What say you, Mr. Townsend?
This one's Mr. Boval. Yeah.
Sorry. I'm going to jump in here. Yeah, I was hoping to get a response filed earlier this afternoon, but we had some trial depths this morning, other things going on. We'll get it filed by the end of the day, Your Honor. The long and short of it is I went through all of our discovery. As far as I can tell, I've got proofs of service for all these things. They are bait stamped. They are part of discovery. There are ally records attached as Exhibit 6 as plaintiff's response to our motion on a similar incidents that we're hearing today. But I will put that into the pleadings and file our response with proofs of all the same.
Okay. And as far as you know, there simply is nothing else that can be produced. I mean, you're going to take the position on Monday. There's nothing else that can be produced that's responsive.
I do not believe so, Your Honor. I've got an affidavit out to the client now. Candidly, the former director of security, who I've been working with for 2 years, retired like a month or two ago. So working with his replacement and talking to him, but he should be available for trial next week too, if we really need him. But yes, we will get that together. I will confirm all of that, and go from there.
Do you know anything about what's called the Hot SOS app?
I do, Your Honor. I spoke with a couple of our witnesses yesterday in security and maintenance. They both confirmed for me that there are several records that we produced as early as March 2024. I believe they're labeled service orders. They are a carbon copy printout of what you would see when you look up the Hot SOS application. Those witnesses are Alex Serva and Mike Moselle, as well as the new director of security, Kristen Meyerholtz. And that's consistent with my recollection of conversations with her predecessor, Pat Boyd, who's a witness in the case and is the one who recently retired. Effectively, Hot SOS is a maintenance-based app, Your Honor. All it does is it's almost like a 911 call log. And so I don't think I could share my screen right now, but I'd probably pull one up.
Could we do that? Because I've never seen what you're talking about. And
Yeah,
do you have a Bates number for what you're looking at?
Yeah, I certainly do. As I was saying, Your Honor, while I looked that up, the Hot SOS is it's not labeled Hot SOS on the documents, but these witnesses, multiple witnesses independently to me yesterday in person, confirmed that this is what Hot SOS would show. And I'll pull up the Bates number in a moment here, but I believe this first document as a Hot SOS example is Bates AHC 00000225-226. It's a readout of the Hot SOS call from maintenance done a month after the fall. And this is a good example of where Mr. Serva, who's a maintenance tech, door technician in-house at Amway, explained that things are only going into Hot SOS if, say, not even related to the door. If a light bulb is out in the guest's room, or the toilet's not flushing, or the elevator's not working, and it's something Amway can fix in-house, then they'll have a hot sauce record for it. There are instances where his boss might say, hey, there's a swinging door over here, it's got a loose screw, I need you to go in and just tighten that up real quick, and he just handles it on the fly. He's not going to put it in the hot sauce. And in other instances, as it relates to plaintiff's motion, and this is where I'll brief it, but essentially what he would explain is that for the door specifically, when he calls for maintenance on it, it's to a third-party door service provider. And you can see in the September 23 example with the Bates I just provided, where that goes into hot sauce. It's an automated system. It says door issue. It goes to engineering, and it's automatically kicked out to the engineering team. One of them pulls it into their workload. You just sort of see these calls one after another. That's all it says is Alex Serva pulled into workload. Then it'll say call out to automatic door, or, the third party provider. And then if there is a hot sauce entry, it would say close out on whatever date that is. And there's really no other, evidence that's in there. I can say to Your Honor, as far as the Ally records go, unless you had any other questions about hot sauce, sir.
Nope, I think that is that consistent. I'm not able to see that document right now. The Bates number, Mr. Schwartz, is that something you can look at and determine if it's?
Your Honor, I have that particular document. I guess what I'm looking for, Your Honor, because I don't believe I've been given everything. So what I'm looking for, hopefully, is an order compelling them to provide everything, such that if I start asking these witnesses during trial, I have some recourse. Because I don't think there's I don't think there's any possible way that this is the only document which exists pertaining to these doors, based on Mr. Serva's testimony. One post-accident report, this door has been installed since 1997 with recurrent serious problems. So I have a very difficult time believing that this is the only document which can be produced which relates to this.
Well, as incredible as it may sound, different corporations keep different degrees of record. So it sounds like, although you obviously can cross-examine all of these witnesses on that question, and I think, it's also a fair question. Gee, if you were maintaining these things, wasn't anyone writing it down or documenting it? All fair questions for examination during trial, but you can't produce it if it ain't there, I guess, is the bottom line. So what I'll do is I'll look at that response. I guess my inclination is if the defendant thinks they've produced every single thing that they have, I'll probably reserve ruling on it for during the trial. And if it comes out during cross-examination that there are additional documents that weren't produced or provided for whatever reason, then we can deal with it and the applicability of sanctions at that time. But it's just what I'm thinking. I'll review defendant's briefing and consider it on Monday. So, all right, let's move on to defendant's motions here. Was that the entirety? That was the only plaintiff's.
Your Honor, I had a motion to allow Zoom testimony for a couple of witnesses as well.
Okay, yeah, and that kind of hinges on these dissimilar incidents, right? Because all of these Zoom witnesses are potential witnesses to prior falls.
That is correct, Judge. And there's really only there's two whom we were not able to depose. So, but yes, they relate to the prior incidents. That's correct.
Okay, and I guess I thought what I do in that matter is consider the motion for exclusion of the dissimilar incidents, because obviously whether or not these witnesses testify hinges somewhat on my ruling there. So why don't we launch into that dissimilar incidents motion by defendants at this time. I did review the briefing, and at least a portion of the exhibits were voluminous, and I couldn't understand. I'll be the first to admit which sensors were what I was looking at in some cases there, but nonetheless, my question would be, who's going to handle this motion? Their team AHC.
Your Honor, I'm going to be handling this.
Okay, was that for
Mr. Townsend.
Townsend. All right, good. All right. Well, and looking through them, and I guess the first question that came to me, and perhaps this is a better one to direct, I'll let both sides address it. It's clear that there are incidents involving an east door and a west door. Now, in the overly simple judicial mind, that makes for an easy exclusion. It's not the same exact door. Am I wrong about that? Are these doors, are they the exact same manufacturer and type of door, or are they different? Who wants to enlighten me, or who wants to? So I'll let you go first, Mr. Townsend, since it's your motion.
Sure. And Your Honor, just to flag for the court, I mean, having reviewed the plaintiff's response, there is another argument I'd like to address with the court. But to answer the court's question on this, the court is exactly right. At least if we have to go incident by incident, Your Honor, this case involves alleged malfunctions on the east revolving door, right? So the west revolving door is a different door. I know that in the affidavit of Mr. Panish that was provided to us here on the eve of trial, he talks about the doors being identical, but that doesn't answer the question. The question is location. It's this door that is at issue in the case, not the west door. And I agree with the court that is an easy call to exclude those prior incidents.
Okay. All right. Well, let me jump to Mr. Schwartz on the topic of are these doors so much the same door that because obviously that's a similarity analysis. It does say the same location. Well, off the bat, as Mr. Townsend pointed out, the east and west doors are obviously in different locations. Now, I guess there is an argument that if there was so much similarity between the actual mechanical parts of the door that they were identical, that maybe we'd have something to talk about there. But what's your response on the east versus west door?
Well, that is exactly right, Your Honor. First off, I'll note that I believe that the incidents involving the west door are admissible irrespective of the notice issue, and I put that in my brief. It's relevant to comparative negligence and proximate causation, and that would not be governed by the Freed analysis. But these doors, Your Honor, are exactly the same. Same manufacturer, same size, same sensors, same lack of sensors. Bottom rail sensor is gone on both of them. Manufacturer of the door, international revolving door, the same. Sensors, super scan sensors, the same. The people maintaining the doors, the same. So this would be analogous, Your Honor, to like a products liability case where, you have a Chevy Pinto getting rear-ended at a high rate of speed, it blows up. You have another one, 2 weeks later does the same thing. Well, it's not the same vehicle, but the defect is the same, and it would give notice to the manufacturer. This is analogous to the situation here, Your Honor. These doors are the same for all intents and purposes. There is no difference. I do believe that they are so similar that it does give them notice generally. And Your Honor, this is different than the normal like slip and fall or trip and fall case because the defect is the same in both: improper wing sensor coverage, no bottom rail sensor coverage, coupled with the fact that they are the exact same door. But it also dovetails into the reason that they were negligent, and this is going to be agreed on by every expert, is that they didn't check the doors properly. So if you don't check the east door properly and it hits someone, that should notify you that you're not checking the west door properly because that's hitting someone too. So it is a bit of a different analysis than trying to analyze, for example, a hole in the ground or some stationary thing that doesn't require maintenance, because this stuff does. But I do think that this stuff is so similar, it's identical. And I ask the defendant to point out a single difference between the doors that's relevant to the case, because there isn't one. Now, again, Your Honor, I believe that the evidence of the west doors come in for proximate cause, lack of bottom rail sensor. If it's hitting somebody from behind, that makes it more likely it's hitting Ms. Kanaga from behind for the same reason, which my expert, and really I believe the defendant's expert, will agree. And then also for comparative negligence, Your Honor. If someone is going through the door that's identical to Ms. Kanaga's and they're hit in the same way, defendant's comparative negligence arguments are that they should have used a different door. So I believe that makes this stuff relevant irrespective of whether it could come in for the notice issue.
Okay, and to clarify, the accident occurred at the east door, so that is the exact door where Ms. Kanaga was injured, and the west door is the other door for purposes of this analysis.
That is correct, Judge.
Okay, all right. Response, Mr. Townsend, to these are the same exact door, and thus the arguments that Mr. Schwartz is making doesn't only go to notice, and notice, frankly, is a little stronger if you've got the same exact door, because a problem with one door doesn't necessarily equal a problem with the other, but he's trying to encourage me to look at that through a broader lens, that of negligent maintenance or upkeep of the doors themselves. What's your response?
Well, I have 2 points to start with, Your Honor. I mean, the first point is that Mr. Schwartz is incorrect to suggest that the substantial similarity test is not the test if this evidence is proffered for any issue other than notice. Even the Beam case that he cites as a supplemental authority says, even if you're offering this for negligence or for causation, the substantial similarity test still does apply. And in fact, it's just a matter of degree, the degree of similarity that you have to show. And for example, if you have to show, or if he's offering this for negligence, right, there has to be a greater degree of similarity for notice. I just want to correct the record in the law on that point in the first instance. In the second instance, Your Honor, in terms of whether the doors are the same, I mean, the west door was installed at least 6 years after the east door. We certainly don't necessarily agree with argument, and this is not proof in this hearing. This is plaintiff's argument that they're exactly the same. And I think one thing is also worth pointing out here to the court, Your Honor, and plaintiff's counsel in his response and then now in the argument talks a lot about this bottom rail sensor. And this gets into my concerns about proving causation and how this is going to be done. And that's an argument I really want to make to the court. But the plaintiff's own door expert, Michael Panish, says the bottom rail sensor is not relevant to Ms. Kanaga's fall. He testified about that in his deposition, and he testified about that in his trial testimony this morning, as I understand. And that is really important for the court, right? Because now we're talking about aspects of these doors that may be the same, correct? But they may be totally irrelevant to the causation of Ms. Kanaga's fall in this case. And if the court will indulge me here, Your Honor, this is the major issue that the defendants have here.
And if I can clarify for just a second, and part of my deficit here is I'm obviously much less familiar with the facts than any of the other people in the hearing. But was Ms. Kanaga, is the claim that this struck her in the foot and knocked her down, or that it struck her somewhere else and knocked her down?
Your Honor, their own expert testified that it hit her in the foot.
And Your Honor, the plaintiff's expert has testified it hit her in the shoulder and that the bottom rail sensor is not relevant.
Yeah, I'm sorry, Your Honor. That is simply false. That is simply false. But I'll address that later.
Okay, I'll give you a chance to respond, Mr. Schwartz. That's fair.
But Your Honor, this debate, right? This debate about the doors, this debate about sensors is relevant, and let me explain why. And I think, having read the plaintiff's response, the Elgin sweeper case that we cite, Your Honor, is not only important, but dispositive of how this motion should be decided. The plaintiff's counsel is asking the court for the opportunity to adduce evidence at trial. If you look at his brief on page 9, it says further evidence will be adduced at trial confirming that all these incidents share the same cause. That is precisely what Elgin sweeper says cannot happen in these cases, right? We are the Friday before trial, and plaintiff had every opportunity to develop all this evidence on similarity in discovery and didn't do it. So now he's asking for the court to have 7 mini sub-trials on each of these prior incidents to determine whether they're similar, to determine whether the doors are the same, to determine whether they malfunctioned in the same way. And Elgin sweeper says specifically that is inherently prejudicial, confusing, misleading, and improper. And again, Elgin sweeper could not be more on point here. The court said in that case, and I want to quote because it goes to the 200 plus pages of material that the plaintiff has submitted here. The Court of Appeals said the documentation supplied by the parties supports the conclusion that allowing the plaintiff to attempt to establish the other incidents are substantially similar would allow trial in this matter to devolve into many sub-trials. Such many trials on collateral matters pose a significant danger of misleading or confusing the jury and are not proper. And as the debate here this afternoon shows, Your Honor, that is exactly what's happening. We're going to have to go to trial on Monday, again, only 2 days away, and we're going to have many trials on door standards, on door censors, on causation, on other people's health conditions, on walkers, on canes. That is not what the rule is. Elgin Sweeper says that is impermissible. And even in that case where the incidents were similar, the court excluded them because of this unfair prejudice. So I want to get that on the record, Your Honor, that in the defendant's view, having 7 sub-trials on prior incidents that are totally unrelated to the August 2023 fall that's at issue here is improper. And for that reason, right, and not even having this debate here today, which is not evidence, right? We have to go to trial. We have to develop evidence on 7 other prior incidents. Elgin Sweeper, citing Michigan Supreme Court authority and federal authority, confirms that is not proper. That evidence needs to be excluded. So again, I am happy, Your Honor, this afternoon to engage in back and forth on similarity of doors and censors and whatnot. But I embrace that. I embrace that because that shows that there are disputed issues on causation that A, prevent the plaintiff from meeting his burden on substantial similarity. But B, even if he could, this trial is now going to devolve into trials about 7 other incidents, and that cannot happen, particularly the Friday before trial, a year after discovery is closed.
Yeah, and your argument then is primarily, Mr. Townsend, under 403, that to do that would hopelessly confuse, mislead the jury or prejudice you because I guess, you know, in an understandable respect, putting on a parade of witnesses about accidents with revolving doors at the Amway Grand Plaza Hotel could certainly leave the less attentive juror with the idea that, well, you know, obviously Amway's not paying much attention to these doors, so let's just find them liable without putting a whole lot more analysis into it. So I think I understand the 403 argument.
Yeah, and Your Honor, just to preview for, I mean, we're going to have, you know, a parade of lay witnesses, that's true. But now we're going to have competing expert testimony between Mr. Panish and Mr. Kringle on causation for these prior incidents. Again, these are going to be full trials on prior incidents to determine whether they're even admissible, and nothing could be more prejudicial to the defense. In the Elgin Sweeper case, the Court of Appeals specifically held that that is improper and cannot happen. And in that case, excluded incidents that were, in fact, substantially similar because of that prejudice. And that is the ruling and fundamental basis that we're asking the court to grant our motion on today. But of course, we can have this other debate about, you know, the factual similarity, whatever. But that prejudice, that issue of the mini trials is dispositive of this motion. It is the Friday before trial.
I note in Elgin Sweeper, Judge Neff was confident enough to not publish the opinion, unfortunately. So I can't certainly take it as persuasive or instructive, but not going to be binding. I'll bounce back to Mr. Schwartz.
Yeah, just to touch on the heel sensor, saying that my expert said that the heel sensor was not important is wildly inaccurate. You know, page 40 of his deposition, he's going through the reasons that this stuff happened. What he is saying is the wing sensor should have stopped the door before it even hit her, my client, and really all of the people that are involved in these doors. So if that doesn't happen, that's when the heel sensor becomes relevant. And that didn't happen here, so the heel sensor is relevant. That is his testimony. That's what his testimony has always been. And quite frankly, I find it hard to believe that Mr. Kringle's testimony won't be similar because I don't know what else you can say. Regarding this issue of mini trials, that keeps being said. I don't know what that means. We took the deposition of Mr. Ryman. He was one of the guys involved. It took all of 10 minutes. He said exactly what he said in the report, which is that the door clipped him from behind. It didn't take very long. It was not very confusing. He said what he said. There's no real cross-examination there because he's some witness who was hit by the door. So I understand it's not good for the defendant. And I understand that. But saying that we're going to have mini trial after mini trial, we're only going to have that because the defendant doesn't understand how these doors work, apparently, because there is only one potential cause for the doors hitting somebody from behind. Whether they have a walker does not matter. Whether they have a cane does not matter. And that is because those things are in front of the person. the sensors are behind the person. Mr. Kringle will never say that that would be relevant because he can't, because it doesn't make any sense. So this argument about mini trials, one, it's based on unpublished authority. It would be so prejudicial here to prevent plaintiff from proving notice that I cannot see a 403 analysis which would make sense, because these incidents are so similar and the issue is so important that the fact that we have to have maybe a half day going through them, yes, if defendant makes it more complicated than it has to, they can, but quite frankly, none of the differences that they have cited play any role in technical cause of these falls. And so, I don't believe that saying we're going to have mini trial after mini trial is a fair statement. But quite frankly, if it takes 20 minutes per witness to go through this stuff, I think that that's justified given the importance of the issue to the plaintiff's case.
Yeah, no, I get it. And I do think, that prior incidents, when they're substantially similar, and as of course the Michigan law requires proximate in time, certainly can have some relevance in establishing first notice. And second, really the analysis under that you're suggesting, Mr. Schwartz, under general negligence or negligent maintenance type arguments is really an indicia. It goes both to notice and secondarily, to what they actually did, their performance, their acts at the time immediately preceding the accident in maintaining the actual door at issue. So I certainly can see, where some of the incidents could be relevant. However, I also struggle first, with the number of incidents here and the two different locations. And I get it. I've heard competing arguments today on whether these doors are exactly the same or have somewhat differences. Obviously, the fact that they were installed years apart, perhaps goes to the idea that models change and things like that, even if they're the same door.
Your Honor, can I don't mean to interrupt.
Yeah,
can I
ahead,
touch on
Mr.
that?
Schwartz.
That is simply not true. They were both installed in 1997. I have no idea where defense counsel got that statement.
Okay, so your argument is these two came in two identical doors on the same truck and same day. Well, here's what I'm going to do with this ruling, at least.
Your Honor, may I interject just one?
Yeah, go ahead, Mr. Townsend.
Since Mr. Schwartz interrupted, I hate to do that. Two things. Again, argument are not facts. These are facts that are going to have to be established about these prior incidents at trial. And again, I just want to point out in Mr. Schwartz's response on the mini trial issue, again, he is making the assumption without any proof that the doors malfunctioned and that's what caused these prior incidents. That is an assumption that has not been established. That's an assumption that he and his expert are making. That is going to have to be litigated at trial. And so I have to vociferously disagree, Your Honor, that this is going to be a simple 20-minute per incident analysis. These are going to be full-blown mini trials with expert testimony in a way that the Court of Appeals says is wildly inappropriate.
No, and I do see the argument there, and of course I do also see, I agree, Mr. Townsend, the foundational part of this is to establish that the incident at issue in this case was caused by defective sensors, the two sensors, the wing sensor and the, floor sensor that we have talked about and that the parties discuss in the briefing. And however, I did read at least one examination of one of the experts who said, hey, well, if the sensors are working properly, a door should never hit anyone. In an ideal world, the revolving doors don't hit people because the sensors are working perfectly in them. Now, I'm sure that the number of revolving door cases that exist nationwide, et cetera, probably belie that fact. But nonetheless, I think that is going to be part of plaintiff's case. I would anticipate that he'll put on would be that, these sensors should be maintained, to a fire alarm or no no defects level, and that they thus ought to have prevented the incident. Given that, and given that it is a specific set of sensors that are involved, however, am skeptical that the incidents involving the west door, the other door, would be relevant. And the reason is because, from my limited knowledge of sensors and things of that nature, is of course they are individually calibrated and located on the doors, and it certainly is possible that one sensor, even if it's identical to the other sensor, because of its different setting or calibration, would be working differently and have a different mechanism to it. However, it is easy to see by that same token how the state of the sensors in the east door, where Miss Kanaga suffered her accident and suffered her injury, would be relevant. So I am going to allow, at least initially here, testimony on the incidents of June 6, 2019. That is 4 years prior to this. However, the door was the same door. The testimony of the mechanics of that accident are virtually identical. Not virtually identical, of course. I mean, the identical part is that the door in all of these incidents somehow struck the individual, the customer at the Amway, and knocked them off balance. And so, being the same door, same exact sensors, I would rule that potentially the evidence concerning that incident at the east door would be potentially relevant. I also read in someone's brief, I think that MP refers to Miss Marge Parmalee. I do have to disclose here, I know Marge Parmalee. She was a supporter of mine during my judicial campaign, and I've also attended various other political events at her home. I also knew her now past husband, Paul Potter, quite well. I don't think that's going to influence whatsoever. She plays at best a bit part or a cameo role in this whole production, but I do feel the need to disclose that I do know Marge Parmalee, if it's the same Marge Parmalee I'm thinking of, I'm sorry, Marge Parmalee. Is it Marge Potter or Marge Parmalee?
Marge Potter, Your Honor.
At least
that's what
the
I know.
one I know. I know Marge Parmalee too. She used to be the executive director at Negligence, but I'm thinking of Marge Potter, all the things I said about political support. So I just want to disclose that to both parties. Don't think it's going to make a bit of difference. As I said, this isn't as I view the res gestae witness in this thing. As I said, she's playing a bit part, but I did want to disclose that. As I'm talking about the East Door here, likewise, the incident dated January 25th, 2022, involving JR, and also involving the East Door, potentially admissible, and also the incident of September 24th, 2022. Involving a PS, and that also involving the East Door striking a customer, potentially admissible. For the moment, I am going to exclude the testimony about the West Doors. And I would like to hear the expert testimony and the testimony on causation here. And it would be, at least if another thing, as I, thought through this last night, given the 403 objection, and I am conscious of that, and I'm also conscious of the fact that, these jurors are going to learn more, just as I am, about revolving doors than they probably ever signed up to know. And my experience with jurors is there is a real numbing factor that once they've heard a certain amount of technical testimony about sensors and clearances and distances, striking weight, things of that nature, that they can tend to kind of blend all that together and lose track of the specific facts we're asking them to analyze in this case. So I think that closing that down to 3 prior incidents will, as best I can, mitigate that concern, and also somewhat defendants' concern about, here we got 6, 7 incidents. They show Amway doesn't do anything with their doors. I would agree that would be too broad a, kind of net to cast or aspersion to cast, at least from my analysis of these different incidents. That would be too much. So I think this will keep the jurors focused on the particular door, the particular location of the accident, and the particular maintenance regarding the sensors in that specific door. We do want, the jurors to narrow that down. And so I'm doing that also, limiting these incidents to limit my concerns about juror confusion and about, a volume of incidents that could create that prejudicial effect that the defendants are eager to avoid, and I think should be avoided, and that, the jurors, simply paint it with too broad a brush and say, well, Amway doesn't know anything about doors. They must be liable. That's what the law seeks to avoid in those cases. So I think that the limitation to 3 incidents right off the bat will serve the purpose. I will hear the arguments, Mr. Schwartz, during trial. If you believe that it simply isn't enough, or that because of other evidentiary rulings, all 3 of those don't come in, and perhaps another one would become more relevant based on expert testimony or other testimony that I hear during the trial. So I'm going to make my exclusion of them without prejudice at this time, so you can re-argue it. But just to give you some guidance prior to trial, I think, I certainly would think that 3 incidents involving the same exact door would be relevant. The one involving an accident after this, of course, it has the clearest argument that it would not be relevant. Of course, the condition of the door and things like that might have changed between the incident at issue and that date. And of course, that doesn't have any probative value as to notice. The only notice it could give, again, would be that prejudicial to the notice that, Amway doesn't do the right thing with its doors and kept on with doing business as usual for a year after the incident. May be helpful to the plaintiff, but not the kind of help that the court rules envision. They want it a lot more tightly focused on the facts of the case. So for the moment, that's going to be my ruling on the prior incidents involving the revolving doors. Is that clear enough that you can put that into, let's see, this was Mr. Townsend's motion. Can you put that into an order for me, Mr. Townsend?
I can, Your Honor. I do have 2 clarifying questions.
Sure.
One practical, because again, we're 2 days away from trial. This testimony about, West revolving doors and these other incidents, is it the court's intention to have that as sort of a quasi-evidentiary hearing outside the jury? I mean, the defense would be concerned
in the event that the argument is successfully raised that perhaps some of those would be relevant. I would be willing to at least consider that in the manner of an offer of proof outside the presence of the jury. I would hope we could do that. Of course, once we get outside the working hours of the jury, we also get outside the working hours of my staff and the court security, and I'll engender all sorts of hate and discontent in the courthouse. But we might be able to figure out a way to do that via an evidentiary hearing without, risking ringing a bell that we can't unring. Does that sound reasonable to you, Mr. Schwartz?
Is that with regards to all incidents or just the incidents?
No, just the West Door incidents.
Okay.
I'm going to let you bring in the evidence of the same exact door.
Clear. I am clear on that issue then. Yes.
Very good. Okay.
And I had one other question, Your Honor.
Go ahead, Mr. Johnson.
Part of this motion is that if the court would allow, I think we raised this, if the court would allow some of the prior incidents, or at least allow some of the prior incidents to come in at trial, we did raise an argument about these incident reports. And so again, being on the eve of trial, I think it would be helpful and instructive for us to have an understanding of what the court's position is on the admissibility of those.
Yeah, no, I get that. And as I see it, to some degree, these are, they're not really police reports, because police reports, of course, in criminal proceedings, are a whole different animal. So let's consider them in terms of business records. The danger in there is, of course, that the recorder of the record is taking it, verbatim, as it were, from the person who fell, for example, who may have been the only person present during the incident itself. Now, Mr. Schwartz advances the argument that, Judge, even if that's the case, it's okay because, the employee, after all, is taking it under circumstances that supply certain indicia of reliability. It's the one firsthand witness. They recorded it. what's your response to that, Mr. Townsend, that the, not the original source, there's a different legal term that applies in that case? Let's see here. And I noted that last night, and of course, let's see, transmitted the information. That's the term the court rule or the rule of evidence uses. So what's the response on that, Mr. Townsend?
I think there's two responses there, Your Honor. Again, I mean, certainly if the AHC employee is talking about what they did, that's one thing. I think the cases are clear, though, Your Honor, that to the extent that these statements and these reports, and I'll cite another case, Gath v. Bay Auto Auction, 2006, Westlaw 709499. If the statements in these reports are attributable to a non-employee, right? And I know that Mr. Schwartz makes a lot of arguments about party admissions. And that case is also clear that if the statement is not attributable to one of the defendant's agents or employees, it doesn't come in under as a party admission either. So again, our position is, what an AHC's employee's impression of what somebody at the site said, right? That's still hearsay, and that should not be admissible. They didn't adopt, right? There's no evidence of an adoptive admission. They didn't adopt what this person said, and that's not verbatim what these people who fell said. That's just that person's impression of hearsay, and that stuff should all stay out. That's our position on that.
Okay, well, and I think what Mr. Schwartz is relying on here is Rule of Evidence 803 sub 6 parens A, requiring that the record be made at or near the time by or from information transmitted by someone with knowledge. Well, it is made at or near the time by the employee, and it is transmitted by to the employee, I guess, the person, the individual with knowledge in that case. He thinks that I think the proper analysis isn't under a party opponent because, right, that would kind of exclude these customers, but rather the business records exception. And I guess the business record exception says, well, the Amway employee is going to record these statements, but if anything, the Amway employee recording the statements is going to be trying to protect the interest of the employer, so they do have incentive to, if anything, favor their employer in the nature of their written report rather than, tilt the report in a way that favors the individual making the statement. And I would differentiate this. I had an auto case, where in one of the police officer's reports, he said, "Oh, I talked to a fireman, unidentified, and he said she blew the red light." Well, I didn't let that in. I couldn't identify the individual, clearly, blatantly hearsay contained in a police report. However, these are a little different. These are by Amway employees. They are taking this information that's transmitted by the individuals. I guess, of course, the law always favors first-person testimony when it's available. My first question is, given my ruling today that the first ones I want to hear about are these incidents involving the same door, Mr. Schwartz, can those all be supported by witness testimony without introduction of the internal reports?
Ms. Potter has been subpoenaed, is incoming in live. Mr. Esquivel, in her incident, Mr. Esquivel, it was the Amway employee who investigated this. He conducted his own investigation, and so I could probably get it in through him as well. He's been subpoenaed. He's coming. Okay. Jerry Ryman has been deposed. Mr. Ryman is an 88-year-old man, so we're trying to have his deposition admitted through that way.
Okay, he's the second East Door incident?
He's the second East Door incident. Okay. Ms. Shop is the subject. We tried to take the deposition of Ms. Shop, which is the September 24 incident involving the East Door. Yep. We tried to take that, it was yesterday or Wednesday, but unfortunately, she's older. She's down in Missouri. We couldn't get the technology figured out. Part of my motion, well, I have a motion for Zoom testimony. Ms. Shop, and it's actually Ms. Watson, is the individual that we're trying to have testified via Zoom. She's older. She's in an assisted living facility, and she's down in Missouri. So that was our position on that. But she is willing to testify. We do have arrangements made to have the technology work. And so if she can testify via Zoom, yes, we can support that via live testimony.
Okay, well, what I'm going to do with regard to the admissibility of the incident reports, I will transmit to, as an initial impression, certainly anything the employees observed themselves and recorded, I would agree with Mr. Schwartz. That portion of the report is a business record. With regard to the statements of, information that could only have been relayed to them by other people, that is particularly here, the person involved in the prior incidents. That information I'm going to hold off ruling on, rather not. I mean, obviously, it is hearsay because it's a transcribed statement of another individual. However, because it was transmitted to an Amway employee who then placed it in these incident reports, I think there is at least some light under the business records exception for admission. And further, if someone becomes unavailable, or the testimony of, thinking of an elderly individual here, who may have difficulty testifying or with their memory, becomes unavailable, that opens up the catch-all hearsay exception as well, that allows admission of certain statements under the catch-all. So I'm going to reserve ruling on the admissibility of the reports, the reports as they contain statements of people other than employees of Amway at this time.
Very good. Thank you, Your Honor.
Okay, and Mr. Townsend, you can place that in a comprehensible order, and obviously we can hash the order out on Monday betwixt and between picking a jury in this case. And I think that brings me to economic damages.
Your Honor, I'm sorry. I don't mean to stall us out here. Just to clarify, you're ruling on the October 24 incident. I understand that that's after. I do believe there's going to be testimony. Reason that would be relevant, Your Honor, is it's the same person maintaining the doors who is doing it incorrectly. And our position is going to be that's further evidence that he cannot maintain the doors. So I guess, has the court definitively ruled that will never come in irrespective of any testimony that comes in, or just reserving ruling based on what the court sees?
I will make that ruling without prejudice as well, allowing you to argue it again during the course of the trial. If you think it becomes relevant based on the maintenance guy's testimony, that I thought I fixed these things and, he still can't get it right kind of thing, I'll rule on it at that time, with respect to the same considerations that I thought of today. I want to avoid, kind of the piling on concern that I talked about earlier, and also confusing the jury even further here. I'd really like them to focus on this particular door, and I think they're going to be asked to digest a significant amount of technical information as it is. So I want to keep them focused on the specific incident. That does remind me, I do think one of the experts talked about, boy, that looked like a lot of incidents involving doors. I guess implicitly my ruling by excluding these others would, at this time anyways, exclude that expert from testifying that, this is an excessive number of incidents or things like that. I do think that's fair, because that doesn't take into consideration, of course, all the things that I talked about earlier, the different doors, different sensors, et cetera, et cetera. So I'm going to preclude that expert testimony that, 7 incidents is too many that I read in the briefing. All right, and I think that brings us to economic damages at this point.
Good afternoon, Michael Bovo on behalf of the defendant. Sorry, I didn't mean to cut you off, Your Honor.
Nope, go ahead.
All right, pretty short here. Really, for us, this is just a timeline issue. I think it's July 2024. We have a number less than just under $100,000 for economic damages disclosed in the middle of discovery. That's only
Let me
about
clarify, Mr. Bovo. Was it 104 plus a lien at that point?
I'll be honest, Your Honor, I don't know the answer to that question.
Okay,
the lien
because
that
that's how I
had
kind of read
was-
the responses. Gee, Judge, you got to think about this lien that we all know is out there. That I think it's a priority lien or priority health lien of that nature. But go ahead, Mr. Bovo.
And that, Your Honor, when that came into the picture at the end of discovery, and I'll let Mr. Schwartz correct the record if I'm wrong. I think the lien was like $60,000 at the time, and I didn't understand where from there we get to the $104,000. We didn't have any other discovery responses. And this is why we asked for reciprocal discovery on plaintiff's motion to compel. supplemental discovery last month just on this one issue. We wanted to know what's the latest on economic damages. We highlighted that that is our chief concern. Have they gone up significantly, particularly since 6 months or so had passed since Ms. Kanaga unfortunately passed away by the time we got to the close of discovery. And so I was a bit surprised to see the numbers go up by over 100 grand. And then again, after the deadline to respond to that motion, a couple weeks go by and we get another spreadsheet that's up to over $300,000. And so just the numbers kept going up and up. And that's why we wanted to bring it to the court's attention. And so that's really all I have, Your Honor, pending any questions from the court.
Yeah, no, I do have a couple, Mr. Bovell. And I guess the first is, if I'm looking at this again, and believe me, I am looking at this not in the granular detail that either set of attorneys look at it. But, I look at this and what if Mr. Schwartz is just simply bad at math or is bad at spreadsheets and he had the numbers in the documents, he provided those documents to you, but the number he gave you was wrong. Is there anything to the idea that, you could have gone through there and done the math and asked those questions if the number was actually higher, like it appears might have happened here? Does that, are you prejudiced by the fact that, I guess if I'm sitting there as a defendant's attorney, I might think, it looked like $300,000 to me, but if he's only saying 104, I'm not going to argue with him. What about that, that you had the information to make the calculus for a while?
I think that if you come back to the end of discovery, Your Honor, it's incredibly prejudicial to both the parties, especially the defendant, to prepare for mediation, any kind of negotiations with a number that's being held out as $104,000. It's less than half the final number that came out just a couple of weeks ago on the eve of trial. And I believe, and I'll let Mr. Schwartz correct me if I'm wrong, I think he, in his final interrogatory responses, had the lower number in the 260 range for economic damages, below the 317. In conversations, it sounds like there was a typo with his staff putting that together, although I thought that when we ran the numbers, they did add up to 317. So that was sort of the confusion, and we couldn't come to an agreement on it, Your Honor. And here we are having to take up the motion. So
yeah, no, I understand, and I certainly think one of the purposes of the rules in general are to discourage last minute we refer to as a trial by ambush situation. It's always a little hard to discern that, though, in that if the information was all out there all along, and you've had the chance, Mr. Bovell, I mean, it's not as if you would have to redepose any of these witnesses. It doesn't sound to me as if there is a fact question here as to whether these services were provided to the plaintiff or necessary.
And to that end, Your Honor, where I come back on that, and I completely understand the court's point on that. One, it's not our burden on the defense to prove damages.
Sure.
And so even though we were diligent in issuing subpoenas and securing records, the spreadsheet that I attached to our motion shows, which is built off the spreadsheet provided from plaintiff's counsel in the last few weeks, where we did have things, and I'm perfectly transparent about that. It still doesn't add up to the number that plaintiff's counsel now claims. And so that's part of the issue. And here we are. There are new bills. There are things that we didn't receive. There are a lot of things we didn't receive via subpoena. We just got medical records. And that is not news to anybody. When I get the subpoena in pursuant to the court rules, I date stamp that, out it goes to the plaintiff. So, it's not just we were like hiding the ball, or I had medical records that I wasn't disclosing or anything like that. And you couple that with the representations going into mediation, it really puts us in a tight spot now over a year later.
And point me to where that spreadsheet is, Mr. Bovell. I did see your little, kind of bullet point illustration of how the number increased with the dates. Where's the spreadsheet on your briefing?
That is Exhibit 4 to the motion, Your Honor.
Okay.
Page 37 of the PDF.
Okay, I do have that here. Let me take a look.